This is Michael Popok with a special edition of Legal AF After Dark, the Michael Luttig edition. I had the honor and privilege of interviewing Judge Michael Luttig, whose social media postings and advice to Mike Pence helped save democracy, who's a constitutional scholar of the First Order, who's filed many amicus briefs at the United States Supreme Court. Had him at a long, an unfiltered interview, and here we're talking about his impression of what went down in the oral argument at the Supreme Court this past week related to the 14th Amendment, Section 3, and mapping it onto the conduct of one Donald Trump. Judge Luttig, many people involved in that room have either clerked for him or his colleague, and he had some hard-hitting opinions about what he observed during that oral argument. Take a listen. Let's kick it off, Judge, with the Supreme Court and the 14th Amendment in Section 3. You've got 14th Amendment, Section 3, a Reconstruction era amendment within a set of amendments by the Civil War generation to address insurrection, uprisings of rebellious states and people, to ensure civil rights for newly freed slaves. You called Section 3 the constitutional safety net for American democracy. Tell our audience what you met, and then we're going to go right to the oral argument and what you observed.
Yes, Michael. It is. Section 3 of the 14th Amendment is literally the safety net for American democracy. That is the Constitution's safety net for American democracy in this most fundamental of respects. Section 3 disqualifies any person who, having taken an oath to support the Constitution of the United States, thereafter engages in an insurrection or rebellion against the United States Constitution. And this case involving the former president, as I've said, is the quintessential insurrection against the Constitution of the United States that was contemplated and forbidden by the framers of the 14th Amendment as it relates to democracy, because there is no more fundamental insurrection against the Constitution of the United States than is the insurrection that the former president engaged in on January 6, 2021, which is to say, on that day and the surrounding days, he attempted to remain in power beyond his constitutional term of 4 years. He attempted to deny his successor, Joe Biden, who had been lawfully elected President of the United States of America, his powers of the presidency to which he was entitled, preventing for the first time in all of American history the peaceful transfer of power. The framers it was as if the framers of the 14th Amendment foresaw January 6, 2021, and provided that America would never again have to witness another January 6. That is so perfect an example of what the framers intended, and unquestionably intended, that it was almost precious of the drafters of the 14th Amendment, Michael.
Yeah, so I've always, I've agreed with your analysis, but you also talked before the oral argument about that there were no legitimate off-ramps, that this Supreme Court, as uncomfortable and unsavory as the position they found themselves in to take, that they would have to address the issue of whether Donald Trump had engaged in insurrection or rebellion against the Constitution, that it was the role of Article 3 judges and the federal judges to make that decision. But we saw nothing but off-ramps led by John Roberts, but joined by even Justices Kagan, of course, Kavanaugh. What was your takeaway? Because you anticipated that they would try to take off-ramps, but that they shouldn't. What did you see or what did you hear in the oral arguments about, and I'll frame it this way, Justice Roberts, Chief Justice Roberts, who's trying to get this coalition together, this consensus together, took the position that the 14th Amendment is all about restraining states. And it's about making sure that states and rebellious states, right, don't do something. So how could we find in there that states would have a role under the 14th Amendment, Section 3, to ban a person for federal office, for the highest office of the land, the presidency? That seems incongruous. And then we were off and running, for a 2-hour oral argument. What did you find about the arguments made? I know your former law clerk, Mr. Mitchell, was representing Trump in this. What was your takeaway from the oral arguments?
I would begin, Michael, with the reminder to your audience that I have revered the institution of the Supreme Court of the United States since I was 18 years old, 16 maybe. And to this day, I revere the institution of the Supreme Court of the United States. What I saw and heard Thursday was the single most remarkable argument in the Supreme Court of the United States, certainly that I've ever heard or witnessed, and I believe must be the most remarkable argument that's ever been made in the Supreme Court of the United States for these reasons. The court was presented with 6 to 7 separate fundamental constitutional questions involving 6 or 7 different provisions of the Constitution by this case. The argument lasted for 2 hours. I believe that the Supreme Court never once engaged itself on any one of those 7 fundamental constitutional questions. And by engagement, I'll explain. There were a few times, but only a few times, Michael, that the court brushed up against one or more of those fundamental issues that it had to resolve to decide this case. Even in those very few instances, the court only brushed up against them. It did not discuss those issues with counsel. Okay, here's the proof of that. As you noted, Jonathan Mitchell was a former law clerk of mine. After me, Jonathan clerked with Justice Scalia, my mentor. By my count, as many as 6, 7, or 8 times, Michael, a justice of the Supreme Court would, in the language, as you know, of argument and asking a leading question of Jonathan Mitchell, intending to help him in his argument on behalf of the former president. And in some number of those instances, the justice would say something to the effect, it seems to me that this provision makes your argument for you, Mr. Mitchell. Please respond. In every one of those instances, Mr. Mitchell said to the justice, well, Your Honor, Actually, that does not support my argument. And in the remainder of those questions, Jonathan Mitchell would say to the justice, it doesn't support my argument, but if it does, it would only support it a little bit, down to the final questions of great significance to the case, where on the question of whether a president is an officer of the United States, the court asked Jonathan, well, we thought that your main argument was that the former president was not an officer of the United States. And Jonathan Mitchell, in the most truthful, honest, forthright argument, I believe, to the Supreme Court in history, said, even as to that argument, well, Your Honors, that's not really our main argument, because we recognize that that's a very difficult question for us. That's a long-winded way, Michael, of explaining for your viewers exactly what happened in the courtroom on Thursday.
Yeah, we're here for the long-winded, Judge.
Let me say, I didn't get to my main response to your question. It was clear to me from the first several questions by the court that the Supreme Court of the United States did not intend ever, in this case, to decide the question whether the former president is disqualified under the 14th Amendment. What's more, by the time the argument was over, it was crystal clear to me and to others who study the court and the 14th Amendment that I don't believe that the Supreme Court intends ever to address the question of whether the former president is disqualified under Section 3 of the 14th Amendment. And if you want, I can explain that, but I'll leave that to you.
Yeah, I totally agree with you. I don't know if this is going to be 8-1 or 9-0, but the off-ramp that you feared quickly coalesced and emerged for me in the beginning of the oral argument. They spent, other than Ketanji Brown Jackson, they spent no time talking about insurrection, which was chalked off as by your former clerk as just a riot that had gotten out of control, but not an insurrection. Kavanaugh raised the issue of insurrection by asking Mitchell, well, what if your guy or anybody, this is my paraphrase, what if the person had been indicted for and convicted of insurrection? Would that have taken that person off the ballot? And Mitchell said it would, except for the immunity, and we'll get to immunity later, that the president, we argue, continues to enjoy. Let me ask a question this way, Judge. The language chosen by the drafters of the 14th Amendment, Section 3, was very specific. I mean, we all have to believe that they chose the words they chose for a very good reason and not other words. They didn't say indicted and convicted. They didn't anticipate trials. They said that if the person engaged in insurrection or rebellion against the Constitution, and then the rest of the 14th Amendment, Section 3, this Supreme Court seems to believe that it's not self-affecting, that it needs to go back to Congress, of all things, of all institutions, even though there is a role for Congress that's in the 14th Amendment, but not in this section, for them to determine whether the person engaged or not. If that's true, I think we already did that with the Jan 6 committee. But in any event, what should have been the role of Article 3 judges or judges to determine whether somebody engaged? Because this is a court, as you just noted, that doesn't want to touch that with a 10-foot pole.
Michael, thank you for asking the question that way, and gives me the opportunity to tell your viewers exactly what the court's thinking and what it most likely will do. as the former president's lawyer argued in his reply brief at the 11th hour, days before the argument, the president's position literally now before the Supreme Court is that the Supreme Court itself does not have the power to decide whether the former president's disqualified now or ever. And as you know, when I saw that very clear argument in the reply brief, I wrote on Twitter just so the country would understand what the actual argument by the former president is. Again, they argued to the Supreme Court of the United States that no court in the land, especially the Supreme Court of the United States, has the power ever to decide that the former president is disqualified. So that leads me to the off-ramps. It is not a legitimate off-ramp for this Supreme Court to say that Section 3 is not self-executing. It's not a legitimate off-ramp for this Supreme Court to say that Congress and only Congress can decide whether the president's disqualified. Both of those arguments it's not possible under the Constitution to hold either of those. So, assuming for the moment that I'm right on that, what did I hear the court saying that it wants to do? Loud and clear, all 9 justices were coalescing, not, Michael, around the view that Section 3 is not self-executing, but rather around the view that the states don't have the power to disqualify a presidential candidate and a presidential candidate only from a primary ballot. So if the Supreme Court were to, let's zoom back out so folks can understand exactly what the implications of that holding would be. First off, if they did that and nothing more, then all that would happen is that the states would not be allowed to disqualify the former president during the primaries. And it would leave for another day whether the states, acting under the electors and elections clauses of virtual plenary authority, could determine whether to disqualify the former president for purposes of the general election. That's if the Supreme Court did what I said and said nothing more. Now, as to doing what it wants to do or seemed to want to do, disqualify, remove from the states their almost plenary power to disqualify the president from the primary ballot. That's what, for the life of me, I don't understand that they could ever do, because there is absolutely not a basis in the Constitution or laws of the United States for the court to hold that the states have the power to disqualify any other person for an insurrection against the Constitution, but just not the President of the United States. So, I don't know, Michael. But I do know that what I'm saying under the Constitution is correct. Now, maybe this is the point where we remind your viewers that it is the Supreme Court itself through Justice Robert Jackson, I think, who once famously said that this court's not final because we're infallible. We are infallible because we're final, and which is just another way of saying the Supreme Court is the final arbiter of the Constitution, and whatever the Supreme Court chooses to do here is the law of the land. It doesn't mean that it has to. It doesn't have to. It doesn't necessarily mean that what they do is even consistent with the Constitution. But in this particular case, I, just for one person, believe that the court had a high duty and responsibility to the nation, at least to decide the questions presented. But from the argument, and we can never know just from the argument, but from the argument, it was clear at argument that they do not intend to decide any one of the fundamental questions presented.
Suddenly, the originalists and the textualists couldn't figure out what text means and if it means what it says, because they don't want to involve themselves in that decision, and they found that off-ramp that you feared. I'd love to have you on one day and talk about what you think the Roberts Court looks like versus the Rehnquist Court or the Berger or Warren courts, but we'll leave that for another time. Well, that's what we do at the intersection of law, politics, and justice twice a week on the Meidas Touch Network on a show we like to call Legal AF. The title is exactly what you think. And if you like lawyers and judges talking about things, they know what they're talking about, you've come to the right network, the Meidas Touch Network. So if you liked it, we do the long version podcast on Wednesdays and Saturdays, 8 p.m. Eastern Time, and on audio podcast platforms of your choice. And then on hot takes like this one, we bring you up to speed. If you know everything you need to know about Legal AF and you're already along for the ride, we appreciate you from the bottom of our pod. If you have no idea what I'm talking about, that was a teaser, an appetizer, an entry into our world we call Legal AF, and we welcome you to join us. So until my next hot take, till my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the Meidas Touch newsletter at MeidasTouch.com/newsletter.